Good afternoon, everybody. My name is Lori Wasserman. I am the chair of the ADR committee for the Baltimore County Bar Association. And this program is being co-sponsored by the Fee Arbitration Program, chaired by Carl Gold, and the Family Law Committee, which is chaired by Carrie Cohen. I see her on there. So hello. This program was actually supposed to be scheduled for last week. We had some issues that required us to postpone it. So we are so grateful that everybody was able to be flexible in their schedules and make it today. I'm really excited about this topic. This is one I've wanted to do for a while now on the fee arbitration program that the Baltimore County Bar Association has. I'm going to introduce our speakers and then turn it over to them. We first have Tom Delina from Bodie Attorneys at Law. He practices in business and employment law, personal injury, workers' comp, and professional malpractice litigations. He represents clients in transactional matters as well as maintains an active trial practice. And then we have Erwin Kramer of Kramer and Conley. He has served as lead counsel on behalf of Fortune 500 companies, insurance carriers, and businesses throughout the world in complex civil lawsuits, commercial and real estate cases, intellectual property, media law, class action lawsuits, serious personal injury, D&O cases, and business dispute. And he's also devoted a significant portion of his practice to the defense of his fellow attorneys in professional malpractice and disciplinary matters. And we also have Ari Kodak, who is an assistant attorney, state's attorney for Harford County, and he is a frequent volunteer with the fee arbitration program, as is our other speakers have direct connections to the program as well. So without further ado, I'm going to turn it over to Tom, Ari, and Erwin to tell us about the program and how it can help us lawyers.
So I think if Ari, if you could just describe your experience with fee arbitration, a little bit about the process, I think that would be helpful for everybody.
Great, thank you, Tom. So it is little known and sometimes overlooked, but once the wheels start turning, most of the participants find it to be an actual very smooth. So normally how it works is that the fee arbitration committee will get a referral from Rachel's office. Then there's a vetting that takes place to make sure that there's no conflicts of interest. And then which point it's put out to the members of the fee arbitration committee to see if they can get a panel. I'm trying to remember the amounts where you have to go from one arbitrator / mediator to 3. Tom, you might be able to kick in that little fact in a second.
Right, 5,000.
Thank you, 5,000. So, but at that point, a chair is usually voluntold to take over and become the chair of that particular panel. The chair then reaches out to the petitioner and respondent, if you will. It's not that formal, but that's how I'm labeling it. And then from there, you get dates and you start circulating dates among your panel members and then among the parties so that we can then either convene in person or nowadays, since everybody does things via Zoom or via Zoom. And during the time period that we convene, setting the date and when we convene the panel, parties are then free to submit to the chair. At least that's what I usually direct them, is to submit it to the chair so that it can then be dispersed to the other panel members. And I say, unless you're marking this confident, that we will then share that with the other side. Typically, parties are dead on in terms of how well organized they are. I've gotten it where it's been notebooks with marked exhibits to just random exhibits in emails, but even then, it's something that can be followed. At the day of the actual panel, when I take chair, and I know Tom can probably back up on this, we tend to let the parties, it's a very free-flowing movement of information. If it's an arbitration, we tend to allow opening statements. You can present witnesses. In a sense, it is evidentiary to the effect that it will impact how we ultimately determine an arbitration decision or an award. Sometimes it can be done in 15 minutes. Sometimes it takes a little while longer to flesh out what's going on. A lot of the times, the parties wind up, after that occurs, resolving it themselves because it allows this free flow of information. In the event that it doesn't, ultimately, once the panel is finished, the panel then convenes, whether it's through Zoom, emails or right then and there and discusses what we think should be the appropriate award, if any. Then the chair then takes care of drafting that award and circulating it to the various panel members as a proposal. Once everybody gives their check off, the chair then submits that to both parties saying, here's the official award. And the again, going back to the calling it the petitioner, if you will, gets to file that in, depending on the level of the amounts that are claimed, district court or the circuit court as an award of an arbitration award. And at that point, it goes where it goes. But the process, at least in my experience, and what I try to foster on the panels that I've chaired is a very good free flow of information. Because sometimes it helps. Sometimes one party just wants to air their grievance. They just want to be heard. And after they're heard, the water doesn't, it simmers down a bit. Other times it comes down to where we have to make that award. At one point or another, the hearing's over and we make the award. Tom, did I miss anything?
No, I think that's it. I think the parties do generally try to sort of self-mediate during that arbitration, which is always helpful. So I agree with you.
Thank you.
So I think one of the issues for us in terms of the committee is that we actually like to get the business. So that we sort of looked at this seminar as a possibility to say, how many of you are going to use fee arbitration language in your retainer agreements? And we have Erwin on the Zoom call because he's going to sort of harness us in terms of what the responsibility is. You're going to get some handouts in a minute, but I want you to take a look, or at least from memory, just take a look at even the Maryland rules as they relate to professional responsibility in Rule 19 through 1.5. And if you look at the Maryland rules commentary, you'll see that it says that if there's a procedure for the resolution of fee disputes, such as arbitration or mediation, the attorney must comply with the procedure when it is mandatory. And even if it's voluntary, the attorney should consciously consider submitting to it. So Maryland has at least a pro-arbitration view of resolving fee disputes as they relate. But there are going to be some caveats. There was a Jersey case that came out last year, I think it was in 22, that significantly, it provided tremendous guideline in terms of what you ought to tell your client, whether fee arbitration is a possibility in the retainer agreement. From my own experience, I have it in mind, and I've used it one time, and the client consented to it. But the caveat that you all have to regard is that your client needs to understand that fee arbitration is a limiting process, and limiting by virtue of the fact that the client needs to know that they're going to waive their right to jury trial, that they're going to waive their right to extensive discovery, if any discovery at all, that if they have malpractice claims, they conceivably could lose those malpractice claims if they don't raise them in the arbitration, and that they have the right still to go to AGC should they have any complaints about fees, etc., as it relates to professional responsibility. There are some states that require that you actually have the client see a lawyer to go over the fee arbitration language, because as we all know, we are essentially fiduciaries, and it's difficult to be a fiduciary if you're providing an advice that may benefit you in terms of resolution. So I think there's a guarded approach in terms of using fee arbitration, and it may be that, and you'll see in some of the things that we've written for today's program, it may be that you want to have an agreement that says basically the parties will agree to agree. The parties will agree to consider at least the use of fee arbitration as it relates to the dispute of fees. Having a generic provision which simply says the parties will submit any fee dispute to the fee arbitration committee or to AAA or to JAMS or anything else is in and of itself, in I think everyone's opinion at this point, ineffective, and you'd be subject to having that arbitration award vacated. Erwin, did I hit the major points incorrectly or correctly?
I think you did, Tom. I'm very much a fan of any type of resolution process that doesn't involve the Attorney Grievance Commission. And certainly the fee arbitration process that's provided by the Baltimore County Bar Association is one such very worthwhile program. And it's one that I would encourage all of us to take advantage of. I've had a client who was subjected to an arbitration notice by a client, and actually arbitrated in front of a panel that included both Tom and Ari, and it actually worked out fine. And I think really for both sides, because I do believe that it does provide the client an opportunity to air grievances in a safe way that doesn't involve airing those grievances in front of bar council. So that's always a very, very critical point. The question is, do we force it upon anyone? And the problems with forcing it, that is mandatory arbitration clauses with clients, I don't think they fly very well in consumer contracts. So if you're representing someone in a divorce, for example, there are a lot of states that believe you have to have informed consent. What does informed consent mean? Well, you have to spill a lot of ink in that retainer agreement. That alone to me is a problem. When you're spending a lot of time explaining in writing at the outset of a relationship all the things that may happen when the relationship goes wrong, I don't know. It's belts and suspenders. A lot of lawyers say, yes, we need to have that in there. It's important, in case something goes wrong. I don't want to leave it unaddressed. But it really does kill the romance right up front. And so I think if, at least from my perspective, I look at retainer agreements in a couple of different ways. One way is, yes, it protects me as the attorney, and it protects the client in terms of clarifying the rights of the parties to the contract. But if we really wanted to provide for everything that could possibly go wrong, we'd be handing our clients a 10-page retainer agreement. And so you have to balance that with the palatability of getting a deal done that is palatable, that will not send your prospective client running for the hills. And the problem with any rule that requires informed consent is that if you have, for example, a mandatory arbitration clause, you have to go through the pros and the cons and all of this. I mean, it could take more than a page to do that. And even then, I find when there are informed consent requirements, courts and an attorney by the name of bar counsel will scrutinize that for anything you might have missed. Is there something else you could have advised the client? If so, they're going to scrutinize that very carefully, take a microscope to the language. It just doesn't work out well in the end. And the MSBA Ethics Committee has rendered the opinion that if you're going to have mandatory arbitration clauses, at least for certain types of claims, not necessarily for fee disputes where it's somewhat unaddressed, that you even have to provide the client the opportunity to consult with independent counsel. Well, for God's sakes, particularly in a consumer scenario, they're hiring you as an attorney. They don't want to have to go to an attorney to hire an attorney. So it just doesn't seem to work in consumer contracts. It would be fine if you're negotiating with Microsoft. You're going to do something with Microsoft. They have their own team of in-house counsel, different ballgame entirely. But if you're like me, I'm not servicing Bill Gates. I'm dealing with someone, oftentimes attorneys, but I'm dealing with people. And so I do think that it may be helpful in a very positive way to flag the firm's support of such worthwhile programs as the Baltimore County Bar Association's program. But to put teeth into that language that would then trigger some informed consent obligations and the like, to me, it's a killjoy.
Well, hold on. Let me just say this. And appreciative of Lori's introduction of me. It's this an active trial practice. I'm sort of mildly retired at this point, so hence the appearance. But let me just say this. I had the opportunity to look at a large firm retainer agreement last year because of we added additional counsel. That retainer agreement was 7 pages long. And it went over to my client and I had to explain everything in it. It had everything in it that you can imagine. Conflict language, preservation of documents, choice of lawyers, the ability to reassign the case from other lawyers. Everything was in that agreement to the point that that client either was mesmerized by the agreement or they just simply signed it because ultimately I said, I think we can trust these guys. So I don't think there's anything really terribly wrong with having a provision in that says, look, here are the pros and cons of fee arbitration. And I think depending on your relationship with a client, if you want to offer them the opportunity to consult with another lawyer and to say, look, I'm even happy if you want, I'll spend some money and you can go over and see Kramer for a half hour or 45 minutes and I'll pay for it. It's no problem because I think it benefits both of us. So I think ultimately the issue is how do you satisfy your fiduciary obligation? And I think you satisfy that by providing as much information as possible, by creating trust in what you're doing. And therefore the relationship in the beginning will be founded on that ability to be trustworthy of each other's side and opportunity. I mean, I wouldn't want to engage a client where I didn't offer the opportunity for fee arbitration if that was the case. And certainly their reaction to it may be a killjoy for me. I want, well, let me just say this. Every state encourages the arbitration of fee disputes, every state. Now, some states require that you actually get independent advice of counsel, like Michigan and Ohio. Jersey wants you to have a 2-page document on conformed consent describing the program. Maryland, as Irwin says, takes the point of view that there's got to be informed consent and the opportunity particularly to consult. But I think it's in the way that you manage that beginning relationship is what's going to turn it in your favor. And I think ultimately in the favor of a client. I mean, take note of this, that the Maryland commentary suggests that if the client wants fee arbitration and it's binding, you've got potentially an obligation to engage in that. New Jersey, with a very stringent court decision last year, says exactly the same thing. So the ethics folks are telling us that if the client wants fair arbitration, you've got to step up and go ahead and proceed and participate. So it's a matter of the delivery. I think it's a matter of educating the client. Many clients, this is the first time they've ever hired a lawyer, so nobody really appreciates it. But I think if you can explain it and offer the opportunity for independent counsel, I think you're going to have a better relationship, not a worse one. So that's our counterpoint.
Yeah, well, let me also, I've just sent all of you, hopefully it got to you by virtue of our chat mechanism, some of the language, the soft approach, I guess, that I was advocating for. Should you have any question, or can you tell them this in the retainer agreement? Should you have any question or concern relating to your bill, our attorneys will always be available to review them with you. In our experience, billing disputes are rare, and open communication helps to avoid or resolve such issues. But in the unlikely event that we reach an impasse, we support the Baltimore County Bar Association's efforts to foster positive attorney-client relationships through fee arbitration before neutral arbiters who volunteer on the association's fee arbitration committee. So in that sense, what I've tried to do is provide some language that flags the opportunity or the alternative if something were to go wrong, but to do so in a way that further enhances your credibility as counsel. So if you're going to do something and take the soft approach, that might be an option for you.
Yeah, and I drafted 2 different arbitration clauses. One is a 2-paragraph, and I think, Rachel, you might be able to share that at this point. It might be helpful. I think it's put in as one PDF, but if you want to put it up on the screen. One indicates that if there's a dispute, then the parties recognize that it's going to be binding. Committees made up of attorneys, not judges. If you have any questions, it provides as much informed consent as I think may be necessary to fulfill your ethical obligation. The other one is that if the dispute arises concerning fees, that the parties will at least consider arbitration, but the client deserves to receive the advice of an independent counsel before making that determination. That's sort of a retrospective clause. So in other words, if the parties have found themselves at the end of representation in a fee dispute, the parties would at least consider fee arbitration. And at that juncture, I would suggest to you that they probably have already spoken to a lawyer. So receiving that information is probably going to be helpful and satisfactory to them.
It's actually at the end of the handout,
Yeah,
Is it like at the very end, like page
very
32?
end, very end, very
Got
end.
it. Okay.
yeah, keep going all the way down. I'll recognize it. It's on, yeah, there you go. There's.
All right, so if we look at that page, if I may, just a couple comments, and that is that if this is the attempt to provide informed consent, and I guess we need to clear that text recognition notice so everyone can see all the language on this page. I mean, any Monday morning quarterback can look at this language, very well drafted. What are we doing now?
Sorry.
Okay, anybody can look at this language, next page, please.
Yeah.
That and say, well, you know, you didn't mention enough about the right to trial by jury and that this is a waiver and that this and that. You know, the problem is that unless you're willing to spill a ton of ink, which has its own problems, you really have to make, I think, a business decision in both directions. There's certainly good business reasons that you want to have an arbitration clause in there, but there are also business reasons for maybe not going in that, at least fully in that direction. I think it really depends. My style of retainer agreement is a letter. And it's a letter that has my signature at the end, and then it has a space, accepted and agreed, and so forth. You know, why do I do it that way? Because yes, it's a contract, but I just find it to be a bit more user friendly, even when I'm dealing with attorneys who themselves may have retainer agreements that are contract formatted, if you will. That's just my style. Obviously, how much or how little of this you do ultimately comes down to your style and what you believe to be best in light of the nature of the clientele and the kinds of disputes that you're seeing. But I will tell you that if your practice is one where fee disputes are a common occurrence, then we need to look at something a little bit more deeply than just what you have in the retainer agreement.
Erwin, let me ask you a question. So looking at this, and you can go ahead and tell me I'm wrong, but because I drafted this, but would I suffer a AGC complaint or breaching a fiduciary duty or not complying with communication rules under the professional responsibility rules if I use this and it was signed and accepted to both form and content as a separate piece of paper to the retainer agreement?
I don't know that it has to be incorporated into the retainer agreement itself. And I don't know that you should suffer any consequence for using a form drafted this way. Obviously, your intent is to provide for an alternative method of resolving any dispute that might arise. I think the devil's in the details in terms of what actually develops in terms of the dispute itself. So, for example, if you have an arbitration clause, and whether it's by separate contract or within the retainer agreement itself, and your client has buyer's remorse on it,
Right.
but you're gonna go, I've got a contract and we're gonna go to arbitration whether you like it or not, you know, that is an invitation to go to the complaint department located in Annapolis.
Right.
So in some ways, the way I kind of look at these things is, sometimes it's nice to have a binding just because it really encourages the client to honor it and go that direction. But at the end of the day, if that customer is unhappy, you have to weigh your contractual rights against concerns that you may have to respond to a grievance.
Right. Well said.
One thing I want to add that we along is that this process, from the moment that we're paneled and are getting ready to convene, it is confidential, and all the parties are required to sign that, so that neither the panel nor anybody in the parties should ever be called to testify on anything that's shared within the, absent some super intervening law, cannot be called to testify about what happens during the panel.
And Ari, I think it also might be helpful to explain sort of the tone of these proceedings, because I think that the tone of the proceedings is a much more conciliatory one than you would find in a courtroom process.
Absolutely. It's very, as I mentioned earlier, it is meant to sort of cool down everybody and really be just an exchange and flow of information. I mean, I would almost liken it to the discovery process, but we all know how contentious discovery is. So I don't want to, I'm afraid to use that phrase, but it's not pointing fingers. It's not cross-examining. I know that there are some practitioners, if they've been on my panels before, I actually, when they start to get into that little cross-examining, because it's natural for all of us to do that, especially with lay witnesses, I kind of caution them that this is not an evidentiary hearing, and just to take it back a notch, because it's important that nobody starts to ramp up, because then we're not going to accomplish everything, and everybody picks up their arms and is ready to fire, and that's not where we're headed. Thanks, everyone.
Attached to that PDF, Rachel, is another sample that could be used, and it's a sort of an agreement to agree. You just passed it. No, you just passed it. There you go. And this is, one that just puts the idea of fee arbitration in everybody's head. Doesn't necessarily commit to it. It's just an agreement to agree, which is generally not enforceable anyway. But Erwin, what do you think of this? Is this something that could be workable? Is this something that would be fair to the client?
Yeah, I think it's fine. I think that, or the language that I had distributed, either way, it's, this is a little bit more legalistic in the sense of saying, well, you have a right to advice of independent counsel because you might be waiving valuable rights or benefits despite the efficiency of the process. But it's certainly fine. It is something that flags the issue, and it may well be, depending on the client, that it may be in the back of their mind that if there's a problem with the bill that can't be resolved, there is a process that doesn't involve me running the commission. I mean, that's really the key. Yes, you want to get paid, and yes, you want to resolve any disputes, but you want to do it in a way that keeps it all about money and not threatening your license to practice law. For me, that's always the key.
Right. Okay. All right, Rachel, I don't know if we have any questions or something, unless anybody has anything substantive beyond what we've already talked about.
I actually have a question for the panel. I was just thinking about this when you're talking. Does the case have to actually be a Baltimore County case, or does it, if it's a case that's filed in a neighboring jurisdiction, would the panel hear it, or is that something you have to go to the state bar for?
It's actually, I can answer that one for you, Tom and Ari. It's where the attorney is located. So the MSBA handles matters that we do not. So if the attorney's main office is located in Baltimore County, and let's say they send it in and they file it with the MSBA will forward that to us. There's a rare circumstance, in fact, we dealt with that recently, and I'm not sure it's been resolved, where everyone was conflicted out here. So we asked the MSBA to handle it, and they, because of that reason, and they sent it and they said, oh no, this is Baltimore County, we can't handle it. But
Really?
it's not where the case was, Lori, it's where the attorney is.
So I'm assuming if the attorney has multiple offices, they can go anywhere. They have Carroll County, Baltimore City, they can still use Baltimore County, presumably.
We've never turned anyone away if they have an office in Baltimore County. I will tell you the MSBA are real sticklers. Like, I think that they use whatever address the person has on file with them.
Yeah, gotcha.
So if they have a Baltimore County, if that's their primary address, they will not handle the fee arbitration.
Yeah, and the MSBA process for fee arbitration is far more detailed. I mean, they talk about a settlement facilitator, they talk about mediation, that, there's many, many steps as opposed to ours, which is much more streamlined. So.
But I think the reason why that happened is because our committee does need more members. I think it's clear that, if that many folks are conflicted out, we obviously need more. So I think Baltimore County has a lot of qualified attorneys who would be wonderful assets to the fee arbitration committee. So decided to put a plug in for that.
Yeah, absolutely. It tends to be the same several people. Tom and I see each other a lot on these, and we don't mind at all. It helps to have a little diversity on it.
Right, Ari, and the pay is phenomenal, isn't it? I mean, it's
well, if you're in Cody's conference room, there's a plug. I think you get free drinks and coffee. So
right. Okay.
Washington, D.C. has a mandatory type of fee arbitration that if the client wants it, it will be binding. And that actually I've dealt with a few times. That kind of works well in keeping some grievances down. Now, I don't know that Maryland is going in that direction. Maryland usually waits until 49 other states have adopted something before even considering it. But it does show that that this method is a very effective one. And also, I will tell you that when I've represented law firms in fee arbitrations in DC, clients actually look at it as like another attorney grievance commission. But the beauty of it is that there are no licensing consequences to the firm that's involved. So they will often write diatribes about what a lousy lawyer you had and all of that. And so I think that it provides a certain valve to vent frustration. So anything of that kind can be extremely, extremely helpful. But I will also say that you would prefer to avoid arbitration as well. In other words, you prefer to take an approach that hopefully gets these things resolved without submitting to either a neutral arbiter or a court process. And where I have found issues, it has been the attorney that says, look, I've earned this money, damn it, you're going to pay up 100%. And sometimes what it's really about is saying, you know what, I'll let some other God handle this person. I'm going to spend my time on people that really appreciate what I'm doing for them. Right. And yes, you're going to lose some fee that way. But what you might gain in return is some peace of mind and the ability to take the resources that you would have put into collections or possible retribution in the form of a grievance and put that into making money, representing clients who actually appreciate what you're doing.
Agree.
Having sat on peer reviews before, I know sometimes there are disputes that make it to that level, where it involves a fee dispute. And what happens, what I've been able to flesh out, whether I've been a chair of the committee of that particular panel, or, and I'm talking about peer reviews, it comes down to communication. And so I think what the Fee Arbitration Committee allows to happen is that free flow of information. Is it going to stop a referral, a letter to the AGC? We'd like to hope so, but ultimately, if somebody's got their, got it in their, be in their bonnet, they're going to do it. But that's just something I just, as Erwin was talking about, is thinking, a lot of the peer reviews we sat on that involved fee disputes, there was just this lack of communication, both directions. And I think that's where we can fill that void and sometimes sort of quash the fire that's about to begin.
Yeah, I'm definitely not one of the people who believe the customer is always right. In fact, I've seen enough in representing lawyers to realize that the customer is often wrong. But what I do believe is the customer is always dangerous.
True. Tom, there's a question that was asked of us that involves how confidential is the panel and what happens, and can they talk about it? Let me read it directly. How confidential is our arbitration process? What can either the attorney or the client say afterwards about what happened? And I think the best thing to do is to show the non-disclosure confidentiality agreement that we have
Right.
signed. That'll give you an idea as to how confidential it is. I can tell you, this is coming from David Mahood. Once it's over, it's over. I don't discuss it with anybody. I even among like Tom and I, we don't talk about we may reference a certain day or something like that. Like, remember that panel that went 8 hours, but we don't discuss anything outside of it. And the attorneys that I've dealt with that have been a part of it never have ever approached me outside of that, not connected with it, meaning where, you would have ex-parte communications where they were submitting things prior to the panel convening. It's never, ever come back up. So I know that doesn't really give you much confidence, but if you look at the NDA or the confidentiality agreement, I think that might help you.
Anyone else have any other questions from the chat or want to ask directly? Well, if anybody does, I'm sure that any of our panel members or Rachel would be happy to discuss this topic in further detail and preparing for this program. I know I learned a lot from just talking to them and hearing about this great program, but everyone's going to get materials. It's got the sample language in it. It has some articles on the issue. It also has in it some links as well, including the link to the Baltimore County Bar Association's website, where you can get the applications to use the fee arbitration program. But having heard nothing else, I just want to thank Tom and Erwin and Ari for their time and expertise on this. I hope everybody enjoyed it. And if anyone's interested in volunteering or using, please reach out.
Thank you.
Thank you.
Thank you very much.
Thank you. Take care,
Take care,
everybody. Have a great afternoon.
Great.
Thanks.
Bye-bye.